Not even a month after the new criminal laws came into force, the Madras High Court has now issued a notice to the centre over the matter and also asked it to respond within 4 weeks. The Madras High Court didn't mince its words as it wrapped the centre and also raised questions over the need for new names for the criminal laws. In fact, the court said that the change in names has created chaos. It has also hit out at the centre for not following proper consultation process, saying that objections and opinions were taken only for formality. The court was also hearing a plea which was filed by the DMK, which has already alleged that the government introduced the three bills and passed them in the parliament without any meaningful discussion. The DMK has also alleged that the name change exercise was an attempt to Sanskritize the names without any meaningful change in the laws. Remember, the Bharatiya Nagarik Suraksha Sanhita, Bharatiya Nyaya Sanhita, and also the Bharatiya Saksha Adhiniyam have come into force from July 1, replacing the Indian Penal Code of Conduct, the Code of Criminal Procedure, and also the Indian Evidence Act. In fact, our guests join us on the broadcast. S. Balan, who's of course an advocate and a political analyst. Abhishek Sudhir, who's an advocate. Let me start with Mr. S. Balan here. Mr. S. Balan, this is of course now a big setback for the centre in many ways because so far only the opposition parties and their governments had been attacking the three new criminal laws, stating that these needed to be tailor-made according to the states, and also there was no proper consultation process also that was followed. But now the fact that the Madras High Court has also pulled up the centre, this is going to be embarrassing for the BJP.
Yes, I read the whole law, new criminal laws. See, my conclusion is it is a tribute to Thomas Macaulay and James Stephen. So they were the draftsmen of IPC, CRPC, and Evidence Act. Now, I further call this as the natural born child of Macaulay and James Stephen. See, I also say that this is not just a old wine in the new bottle. It's also like old wine in a new poison coated bottle. And this three new criminal laws are unconstitutional, anti-people, anti-citizen, anti-national. For the reason that, see, the special laws, UAPA, Maharashtra Control of Organized Crime Act, Karnataka Control of Organized Crime Act, these are all offshoots of TADA, FOTA, and other draconian laws. That is introduced, incorporated in the form of Section 300, Section 111, Organized Crime Syndicate, Organized Crime Act 112, Organized Petty Crime Act 113, just picked up from 15 and 16 of Unlawful Activities Prevention Act. When there is a special law for special situation, why should those acts be incorporated in the name of Bharatiya Nyaya Sanhita? So then comes section 152. 152, it is a reincarnation of the old Seditious Act 124A. Now they have introduced it. Then in the Evidence Act, section 115, see, this is reverse burden, which is against to Article 22, Class 3, Article 22, 21, and Article 14 of Indian Constitution. Therefore, I call it as unconstitutional. See this arrest. Earlier arrest procedure 167, subsection 1, first 15 days, they used the word such custody. See, I make it a point here throughout the world. No country grants police custody after arrest. It is a colonial legacy. The first 15 days could be a judicial custody or police custody. Then what for? Now it is extended to 90 days. Handcuff is allowed.
Right.
Force is allowed. Like that, there are several sections I can quote. Now the entire library of the advocates are redundant.
Right.
It is unfit. We have to throw these books. Why just name changes? I put it like this: 90% Macaulay's James Stephen law, 10% special law that is also enacted by fascist countries. See, the section 107 of the Criminal Procedure Code, any property can be just seized by the police. Therefore, power is taken from the honorable courts and handed over to a head constable, not even IPS officer. In Tada,
Absolutely.
power of the judge is taken under section 15 and given to IPS officer. It is in other provisions, IPS and IAS officer. Now, section 22 of the Evidence Act, new Bharatiya Sakshiya Adhiniyam, that power is transferred to a head constable. Now, head constable can record the confession, which is against the
Absolutely. Mr.
constitutional
S. Balan will, of
provision.
course, get into the details of it, but let me quickly also get in Abhishek Sudhir, who's, of course, here to also talk about it. Mr. Abhishek Sudhir here, S. Balan clearly pointing out all the problematic sections of the new act, the new criminal laws, but also I think the bigger question here, which also the Madras High Court has specifically spoken about, is the nomenclature. Do you see any logic there behind changing the names? Shouldn't the names just have been in English so that every single person across the nation could easily grasp it?
The name should have been in English so that everybody could grasp it. If the gentleman who just spoke is saying that the criminal laws are the natural born children of Thomas Macaulay and James Stephen, then he should welcome the fact that the names are no longer in English. First of all, the Indian Penal Code was known as the Bharatiya Nyaya Sanhita. Yes, the official name was in English, the Indian Penal Code, but the translation was Bharatiya Nyaya Sanhita. The Bharatiya Nyaya Sanhita has become the Bharatiya Nyaya Sanhita. And Bharatiya Nyaya Sanhita is now the official name. Now, the word Nyaya, the word Bharatiya, first of all, the word Bharat is in the constitution. The word Nyaya is not alien to people in the south of the country. In Karnataka, in Telangana, in Andhra Pradesh, justice means Nyaya, Nyaya. You say Nyaya in Karnataka. So the word is not alien. Perhaps the word Sanhita they are not so familiar with. The word Sanhita translates to code. Now, if you don't want any remnants of Thomas Macaulay and James Stephen, then you start first by changing the name. You've called Madras Chennai. You've called Bombay Mumbai. Calcutta has become Kolkata. So what is the problem if that happens? Right? The same way you can say, oh, this is a cosmetic change, you're just changing the name, but it is so much more than a cosmetic change. In the CRPC, in the Bharatiya Nagrik Suraksha Sanhita, as it's now known, there have been more sections. The number of sections has actually increased in the BNSS. In the Bharatiya Nyaya Sanhita, which is the old IPC, several sections have been removed. Several archaic sections have been done away with. Look, I'm a lawyer, Mr. Balan is a lawyer. I don't want to get into the nitty-gritties of individual provisions. Sure, Mr. Balan and his ilk are free to challenge the constitutionality of these laws, and they're doing that before the Madras High Court. That being said, the Supreme Court is also seized of the matter. As far as I am concerned, this petition before the Madras High Court is nothing but a political petition. It has been filed by the organizing secretary of the Dravida Munnetra Kazhagam. I myself am a Tamilian, but I have no problem in learning any word in Sanskrit or Hindi. I also born and brought up in Bangalore. I speak Kannada, which has plenty of Sanskrit words. What is wrong with the indigenization
Mr. Abhishek
of
Sudhir, this
our
is exactly
criminal laws?
Mr. Abhishek Sudhir, this is exactly what the critics are now saying, that why come up with a name that will actually have you giving such long defenses? Why just not name it in English? And let's not even talk about
Sir,
individual
I am
positions.
not
You both
giving
are
you a
lawyers,
long
and of course,
defense of-
you will
No,
talk
you
about
are
it legally as
asking me a
well.
question.
The critics,
No, no,
the
you are
critics are
asking
here
me a
talking about
question about
Article
the name.
348.
I'm
Mr.
giving you a
Abhishek
defense of
Sudhir,
the name.
Mr. Abhishek Sudhir, don't get hyper. Mr. Abhishek Sudhir, don't get hyper. I'm just asking you a question. Talk about Article
I'm not getting
348. I
hyper,
just have
sir.
it
I would
open in
ask
front
you
of
to
me.
check
It
your
clearly says
language
that the
and treat me
language.
with respect.
Mr. Abhishek
Please don't
Sudhir, I'll
use
just
words
read
like
out
hyper.
Article 348.
Clearly, you're not
I'll
familiar
just
with
read
the
out
English
Article
language yourself.
348 that the critics are citing. It clearly says that the language that needs to be used in the Supreme Court for the bills and the acts, including all of those bills and acts that come out, has to be in English. Do you not agree with Article 348? Because this is what critics are pointing out at. What's your defense for that? Right. So Mr. Abhishek Sudhir has now decided to, I cut the call, I believe he's disconnected. So clearly there, this is of course the legal side of it that we're talking about. S. Balan, I believe, continues to be on the broadcast with us. Mr. S. Balan, I was clearly asking Mr. Abhishek Sudhir about the fact that he was saying that you are talking about your individual positions and not the legal side of it. And I clearly pointed to him the particular section that talks about how bills, laws, and acts and also judgments of the Supreme Court have to be in English. This is Article 348 of the Constitution that talks about it, and he just cut the call. So I just don't have a side for him to present right now. Help us understand what exactly is the argument that the people who are now backing this Sanskritized name, what's the argument that they have for it?
Nyaya. Where it's a penal code, why it is the Nyaya? And Suraksha in Bharatiya Suraksha. Security, what security they talk about? That language, whether it is Kannada, Tamil, Hindi, Urdu, or Bengali, Marathi, what language is this? This is Sanskrit, this is Deva Bhasha. Why they wanted to incorporate it? And the entire law is read. It's a mixture of special law and the general law. Nothing more except the nomenclature change. What is the logic in changing the name? In what way it is beneficial to the litigants? What see every law, the ruling dispensation wanted such a draconian law to criminalize the person who believe in a particular faith, Adivasis, Dalits, working class. These are all the people who are affected with the revamping of labor laws, mineral laws, other laws. Everything is denationalized. Therefore, this stringent laws to combat the people of this country who wanted to protect their life and liberty.
Right, Mr. Eswaran, of course, we are talking about how the names should have been in English. This is what the opposition is saying. And of course, we don't really have the defense side of it because as soon as I started questioning the defense side of it, the fact that he was talking about legal aspects of it, and as soon as I spoke about the particular section of the Constitution that talks about names being in English, and also what his defense is for it, he disconnected the call. But appreciate you joining us on the broadcast. Mr. S. Palan has also clearly putting out your point of view and why you think this nomenclature is clearly a Sanskritized version of it and was clearly not needed. And also the fact that you're now talking about all the problematic sections that have been added as well, which makes it a police state instead of actually trying to make sure that this is something that gives justice to all. Appreciate you joining us on the broadcast.